You all see that well enough? Frankly, I'm not sure how to make it bigger.
Thank you all very much for coming out tonight. My name is Jay Weiner. I'm with the Montana Attorney General's Office and a staff attorney for the Montana Reserved Water Rights Compact Commission. As many of you, but probably not all of you, are aware, we've been in negotiations among the state and the tribes and the United States for many years now, actively for the last 5. And what we've released to the public and what we are talking about tonight and soliciting public comment for are the draft documents that we believe are a template for settling the reserved water rights claims of the Confederate Salish and Kootenai tribes in the state of Montana. And what I'm going to do tonight first is I'm going to walk through the guts of that major document, which is known as a compact. The draft compact, it is available on the Compact Commission's website. I believe it's also available on the tribe's website. We've got some copies here. We really are hoping that you all will read it carefully, bring questions, comments, and concerns to us, because our goal is to bring this to the legislature for ratification in January. So as I just touched on, what is the draft compact? It's a provisional draft of a water rights agreement, and that word provisional is important. It's been a long time coming. There's been a lot of work that's gone into it, but we recognize that we're not taking anything to the legislature unless and until it's been fully vetted by the public. And our goal and our charge is to negotiate a water rights agreement that quantifies the reserved water rights of the tribes. And from the Compact Commission's perspective, one of our core tasks in that effort is the protection of existing water users. And so that's a large part of what the compact reflects, both the quantification of the tribe's water rights and the protections that we built in. And I'm going to talk in more detail about those as we move through the compact. Part of the settlement package also includes the ordinance, which is known in the compact as the Law of Administration, and essentially is the Water Use Act for the Flathead Reservation that we are proposing to do. One of the reasons that we are proposing this essentially new Water Use Act for the Flathead Reservation is that in the mid-1990s, the Montana Supreme Court handed down a ruling that said that DNRC does not have jurisdiction on the reservation to issue new water permits. And so since August 22nd, 1996, there has not been a legally valid mechanism on this reservation to develop a new use of water. And so one of the things that we are working hard to do in this settlement, and is reflected in the draft documents, is a mechanism for plugging that regulatory void. Again, it remains a work in progress. The draft that is on our website has 3 gaps, one of which we actually have plugged today. There is new language on the website. I'm going to touch on it briefly tonight. But we have a new section of the compact up on the website for review that deals with what we're calling non-project irrigators. And I'll talk about that in a little bit. But we're working hard to plug the remaining 2 gaps so that we have a complete version. We have not incorporated that language directly into the document yet, because we know that there's enough material out there that is confusing enough that we don't want to start putting multiple generations together. We're soliciting public comment. We run the negotiating table, continue to review the document, to listen to the comments we've received, to figure out what adjustments need to be made or what changes need to be made to these draft documents before each of the negotiating parties is prepared to recommend it going forward to the legislature for ratification. The compact itself is similar in format to other compacts that the state has done. We've negotiated 6 Indian compacts in Montana with the other 6 reservations. The Confederate Salish and Kootenai tribes are the last tribal negotiation that the commission has. The draft compact has 8 articles, but 2 of them are really where the heavy lifting is done. Article 3 is predominantly about the quantification of the tribe's water rights, and also includes language about the protection of existing users. And then Article 4 predominantly has provisions for the administration of those water rights. A couple things about this compact that are different, and I've touched on one of them already, is this unitary management approach. Historically, on the other reservations in Montana, what the state has negotiated is essentially for a dual administration system. And what a dual administration system means is that the DNRC has jurisdiction over the existing state-based water rights. And the tribes have jurisdiction over all of the tribal water uses, which includes all future post-compact development on each of the reservations. In each of our prior Indian compacts, we have closed the reservation to new permits issued by the NRC. What we're proposing to do here instead is to have this single entity, this Water Management Board, administer all water rights on the reservation, whether they arise under state law or under federal law. In addition, this settlement deals with water rights off the reservation, and I'll talk about how we're approaching those as well. The reason we're doing that is there's a specific language in the Hellgate Treaty that courts have interpreted to bring with it the legal entitlement to preserve flows in off-reservation streams that are known as the tribe's usual and custom fishing locations. And so we are working to resolve those claims as well in the settlement. I will now walk through the 8 articles of the compact, some of them more quickly than others. Article 1 is basically just the recitals, who the negotiating parties are, what the legal authority we have to be around the negotiating table, what it is we're doing, negotiating a water rights settlement. Article 2 are the definitions, and these are simply when we use capitalized terms in the document, this is what we mean by it, because these are legal documents, and it may look like they're written in English, but the language usage is very, very particular and very specific, and the definitions are geared to being as explicit as possible about what we mean when we use certain terms. Article 3 gets, as I said, to the meat of the compact. This is the quantification part. It identifies various categories of the tribe's water rights, and these rights are defined in abstracts. We talked a little bit about this at the last meeting. Abstract is a term that can cause some confusion. What a water rights abstract is it is the legal controlling version of a water right. As the Montana Water Court in the Montana General Stream Adjudication issues preliminary and then eventually, we all hope, final decrees, everyone's individual water right in those decrees comes out in abstract. And what we have done in this draft CSKT compact is we've gone ahead and worked to put the abstracts of the tribe's water rights together so that everyone can have as clear an understanding as possible of what the specific water rights are. This is actually a greater degree of clarity and explicitness than we've done in prior compacts. We think this is actually a very helpful way to do this so that everyone is crystal clear on what the rights are, how the rights can be exercised. We have put these up on our website as appendices to the compact. The abstracts in particular are somewhat voluminous. There are 2 binders on the table in the back there that have hard copies of them. I believe we also brought a few CDs, people who really want to peruse them. They're also, as I said, available in PDFs on our website. So the categories of the tribe's water rights, and these are all broken out in individual sections in Article 3. Recognizes the tribe's religious and cultural uses, recognizes the water right for the Flathead Indian Irrigation Project, which includes the right to water that the project diverts off the reservation. And the exercise of these water rights, of the project water rights, are envisioned as being subject to the terms and conditions of the 5th Water Use Agreement. Now, we recognize that that agreement remains a work in progress. A draft of the 5th Water Use Agreement was released to the public for comment, I believe, back in May or early June. There have been significant comments that have been received by it. It is my understanding that the Joint Board of Control and the tribes continue to meet and talk to figure out how to resolve the issues identified in those comments. That process is a separate negotiation from the process that I'm talking about tonight in the compact. That process, the 5th Water Use Agreement, is a negotiation directly among the Flathead Joint Board of Control, the tribes, and the United States. And there are certainly references to the 5th Water Use Agreement in the compact because we are ultimately presuming that there will be a successful agreement, although we are not prejudging what the substance of that agreement will be. So the references in the draft documents to the 5th Water Use Agreement are there so that at such point in time that the 5th Water Use Agreement is concluded, it can be folded in to the settlement seamlessly. If ultimately there's not a 5th Water Use Agreement, while we're trying to take this to the legislature, it's not clear that we have a settlement. We certainly need to go back to the drawing board to figure out how those pieces fit together. So we are obviously paying careful attention to the 5th Water Use Agreement talks, but ultimately recognize that the joint boards and the tribes and the United States need to make their own independent assessments there of whether we have or whether they have an agreement that we can incorporate here or not. So the compact also recognizes the existing uses of water by the tribes and their members. As that we protect existing uses that arise under state law, it's also important to protect those existing uses that arise under federal law. Now, we do not have the sort of inventory of those existing tribal uses, the specific inventory that we do under state law because of the rules of how claims had to get filed in the Montana General Stream Adjudication. We know in the aggregate, based on the technical work we've done on flow data, on Landsat imagery, in the aggregate roughly how much water is being used. But one of the things that we create, and I'll touch on this later, is a registration process of the specific current exercises of the tribal waterway can be recorded and protected. An additional component we're talking about is what we're calling flathead system compact water. It's 229,000 acre feet diverted, roughly 128,000 acre feet depleted from the main stem of the Flathead River, backstopped by 90,000 acre feet of water from Hungry Horse. That's a very significant issue for the tribes. It is a block of water that they will be able to develop through a process before the Water Management Board, but it's very significant for the tribes as part of a wet water block for which they've been willing to bargain for some of the protections for existing users that are very important to the state. In-stream flow rights are another significant component of the tribe's water rights. Sorry about that. These in-stream flow rights have what's known as a time immemorial priority date. That's been judicially determined, and that means that they are the first rights on the system. For those of you who may recall, back in the 1980s, the tribes and the Joint Board of Control went to court over that. The Ninth Circuit Court of Appeals upheld the tribe's right to these in-stream flow rights and made very clear that, legally speaking, those rights are senior to any water right the irrigation project has. And so one of the things that we're doing in the compact in different mechanisms, so these natural nodes and FIP nodes and other in-stream flows, those are three categories, mainly based on geography of where the rights are measured and which reaches are protected. But this is the quantification of the tribe's in-stream flow rights. Again, however, as part of what we talked about with the FIP right, the exercise of these rights, at least the FIP nodes ones, which are those rights that are interspersed with the irrigation project, would also be subject to the FIP water use agreement. And so that's, again, another reason that agreement is important. Other in-stream flows are in-stream flows for reaches that are outside what we call the FIP influence area, mainly but not exclusively on the western side of the reservation. There will be a maximum level of those rights identified in the abstracts, but the rights themselves are not enforceable until several things happen. Particularly, the tribes will need to propose an enforceable flow schedule. I'll talk about that process a little bit later, but that is also a critical component of balancing the recognition of the tribe's rights with the protection of existing users. We're talking about also recognizing wetlands water rights for tribally owned lands. We are not recognizing wetland water rights on privately held lands. Also for high mountain lakes. Again, these also have time immemorial priority dates as non-consumptive water rights. We're talking about recognizing a water right in Flathead Lake to a minimum elevation pool. This is for the entirety of the lake. The tribe's off-reservation claims are sufficient to encompass the north half of the lake, and we're treating it in one place in the compact because it frankly just did not make sense to deal with the lake as two discrete halves. Nobody's talking about putting a plexiglass shield down the middle. Water rights also for the hydroelectric projects that the tribes own. These are distinct from the water rights associated with Kerr Dam, which I'll talk about in a minute. Those are separate water rights. In addition, we're proposing to recognize jointly owned, co-owned water rights for wetlands that are on lands owned by the Montana Department of Fish, Wildlife, and Parks on the reservation. Those rights would be jointly owned. FWP would retain the unilateral ability to manage those rights and manage the land. The Kerr rights are water rights that arise under state law under the license condition associated with Kerr Dam. The tribes have the right to acquire those rights in 2015. The tribes have been very clear they intend to exercise that right. The reference to these Kerr rights in the compact simply are a reflection of the fact that the tribes intend to exercise their right to own these water rights. We are not converting the Kerr rights from state law-based water rights, which they are. We are not converting them to Indian water rights. They will still need to be decreed by the water court in the general adjudication of Basin 76L. So the reference in the compact simply is the importance that the tribes have recognition that they are going to own these rights. but we're not changing any of the attributes of the rights. I talked about off-reservation claims. We are looking at settling the tribe's off-reservation water rights claims with various strategies that involve the Kootenai, the Swan, the Lower Clark Fork, the Upper Clark Fork, and the Blackfoot, the Bitterroot, and then with some Montana Fish, Wildlife, and Parks claims in the adjudication that arise in the Flathead Basin, the Kootenai, and the Bitterroot, and the Blackfoot, and on Rock Creek, which is a tributary of the Upper Clark Fork. In the Kootenai, the proposal is for there to be a main stem, time immemorial in-stream flow right owned by the tribes. The abstract for this right is up on the Compact Commission's website. We did not have it up there when we had our last meeting. It's up there now. The right can be changed to other purposes, and the right is not enforceable so long as Libby Dam remains in existence. And I cannot stress this strongly enough. Nobody around this negotiating table is talking about removing Libby Dam. We contemplate the continued existence of that dam. That dam serves important functions for all of us in western Montana. But this is a for-all-time water rights settlement. And so we do need to incorporate the possibility that at some point in the very distant future, that dam may or may not exist. And so that's the balance that we've tried to strike in our quantification of that water right. Which is what I just said, if the right becomes enforceable, so in some future scenario when there is no longer Libby Dam and the right becomes enforceable, it would only be enforceable against main stem irrigators. One of the concerns we heard from some folks in Lincoln County was, what about folks on the tributaries who rely heavily on that water? We brought that concern back to the tribes. The tribes agreed to negotiate over it with us, and we've come to the language in the draft agreement that protects tributary irrigators and leaves it simply on the main stem. That is an example of how we are trying very hard to be responsive to public comment. And again, nobody is talking about removing Libby Dam. On the Swan, we are proposing a similar approach as on the Kootenai. The abstract is now up on the Compact Commission website. Again, it was not up there a couple weeks ago, it is now. Also can't be changed to another purpose, also enforceable only against junior irrigators. On the Lower Clark Fork, similarly, we are looking at a main stem in-stream flow right. One of the differences between the Lower Clark Fork and the Swan and the Kootenai is that on the Swan and the Kootenai, we're talking about essentially an enforceable hydrograph, which means it's a right with a varying flow level depending on what the water conditions in the year are. On the Lower Clark Fork, we're talking about a flatline flow level that is pegged to the FERC license conditions for the amount of water that has to get passed through the Cabinet Gorge Dam. If that license condition changes in the future, the enforceable level of the right will change along with it. Again, it is enforceable only against main stem irrigators, not on any other kind of water right. And that's an important point. I'm going to make it a couple of times tonight. But on the reservation, off the reservation in western Montana, if you've got a domestic right, if you've got a stock right, if it's a municipal right, if it's a commercial right, if it's an industrial right, none of those rights can be called by the exercise of the tribe's water rights. That's one of the very important conditions that the state has negotiated very hard for in exchange for some of the other concessions that we're making to the tribes. But I think that that is a really important point that can't be stressed enough. If you do not have an irrigation right, and I will talk about the irrigation protection separately, if you have some other kind of water right, this compact wholly and completely protects your use from any assertion of the tribe's senior priority. Milltown Dam is the centerpiece of our off-reservation proposed settlement in the Upper Clark Fork. That's the water right that used to be associated with Milltown Dam. The state presently owns that right. We acquired it as part of the settlement of the natural resource damages litigation that the state brought against ARCO and Northwestern Energy. The tribes intervened in that litigation. They were granted the status by the Court of Natural Resource Trustees. Had the state not acquired that water right, the tribes would have been next in line to buy it. So what we've done, we're proposing as part of the settlement to have the state and the tribes jointly own the Milltown Dam right. Joint ownership essentially means parallel ownership. It's one right with two owners. We are talking about changing the purpose of that water right because it's a hydro purpose right now. It needs to be changed to in-stream flows. That's what the state intended to do when it took it. We're proposing to do that legislatively through this compact process. We also are proposing to make some changes to the Milltown Dam right in a way that we believe strikes a balance between the exercise of that right, because there's language in the consent decree that commits the state to do nothing to diminish the value of that water right. If we diminish the value of the water right, we're in violation of the consent decree. But as part of the compact negotiations, we believe that we have the latitude to make some adjustments to that right in terms of setting some minimum enforceable levels that strike a balance between the ecological benefits that the right is intended to provide with the protection of existing irrigators. We've done a lot of work looking at flow data, looking at current hydrology, looking at current water use, and trying to strike a balance in ways that minimize the impact of this right, which is coming online one way or another because the state's acquired it, on existing irrigators. And again, for all other kinds of water rights, all other kinds of water rights are free from call from this right as well. I think I just covered that quickly. On the Bitterroot, we've got a different water situation. Bitterroot's been recognized as an over-appropriated basin since the 1940s. And we did not believe, the state, as we put our off-reservation proposal together, that we had the ability to agree to a large senior in-stream flow rate on the Bitterroot because it would be too disruptive. At the same time, we recognize that the tribes have a very significant, very strong, very documented cultural connection to the Bitterroot and Salish home country. And so what we propose to do in the Bitterroot is to make the tribes, to afford the tribes a beneficial interest in 3 contracts for stored water that the Montana Department of Fish, Wildlife, and Parks has, and they presently exercise for flow augmentation for fisheries and recreation benefits, which align with the tribe's interest. And that's how we're proposing to resolve the issue in the Bitterroot. In addition to bring the package together, we've also proposed making the tribes co-owners with Fish, Wildlife, and Parks of various recreation and in-stream flow claims that FWP has in the Montana General Stream Adjudication. Those claims are located on the Thacker River in Young Creek and Kootenai, on the main stem of the Bitterroot, on the forks of the Flathead, on Rock Creek, and on several lakes in the Blackfoot Basin. In addition, one of the things that the tribes have done on the reservation is they've embarked on a significant land acquisition program, and many of the lands they've acquired have state law-based water rights associated with them. What we're building into the compact is a recognition that those state law-based water rights will need to go through the adjudication like all other state law-based water rights. That's a recognition in the compact that the fact that the tribes have acquired them does not change the attributes of those rights. That said, if at some point in the future that land is taken into trust by the United States on behalf of the tribes, that does bring some changes. It entitles the tribes to have the priority date of those rights adjusted to a treaty date, but we are also building in the requirement that those rights need to be exercised as they've historically been exercised or go through a formal change process before the Water Management Board, which again is part of the balance of striking the interest of recognizing the tribe's legal entitlements to water with the state's critical imperative of protecting existing uses. So I've talked about this a couple of times, but this is the part of the compact where we specifically talk about it is Article 3I of the compact. And it flatly provides that no non-irrigation right can be called. So if your water right is for any purpose other than irrigation, your water right cannot be called by the exercise of the tribe's water rights. For groundwater irrigators, if you've got a flow rate 100 GPM or lower, you also cannot be called. For FIP water use, which is the vast majority of the consumptive water use on the reservation, we are hopeful that the FIP water use agreement that the Joint Board and the tribes and the United States are working on will strike a balance that provides for the protections for existing irrigators in relation to the exercise of the tribe's in-stream flow rights. And so we're contemplating that the heavy lifting on the protection of the FIP irrigators will be done through the FIP water use agreement because that's where the Joint Board directly has a seat at the table. For non-FIP irrigators, which are those who are, the way that we use that term is basically folks whose lands are on streams that the project uses. We're actually working to put together a map that defines it a little bit more clearly. But the folks who are on those streams who do not have project delivery rights, we are proposing that they will have the opportunity to enter into essentially form agreements. We've laid out the criteria for what goes into these proposed agreements in that new language that's up on our website. It's Article 3I3. That went up on our website this morning. That will enter into these agreements to protect the amount of water up to what the farm turnout allowance might be through the water use agreement process. It essentially protects these folks on par with the protection of project irrigators, even though as a matter of law, these folks are junior, not just to the tribes, but also to the irrigation project. So I just covered all that. For additional points on protection of existing users, we also talked about the non-irrigation rights upstream of the reservation, and I talked about that. Again, no non-irrigation rights can be called. Irrigation rights upstream of the reservation also cannot be called unless they are on the main stem of the flathead or the north, south, or middle forks of the flathead. So if you're irrigating on the whitefish, if you're irrigating on the Stillwater, you cannot be called. There are a total of 93 irrigation claims filed in the Montana adjudication for irrigation water rights on the main stem of the flathead and on the north, south, and middle forks. The hydrology work that we've done suggests that there is, based on the 70 or 80 years of records that we've looked at, no scenario, no imaginable scenario where there is an actual water conflict between the tribe's rights that were proposed to recognize in this compact and those irrigators. There's no scenario that we can imagine where a call would actually have to be made. At the same time, the tribes rely on that water coming downstream for the water rights that we're recognizing here, and so the tribes are unwilling to agree to say that we can't make any call theoretically under any circumstances. And so this is how we try to strike that balance of interests. One of the two gaps remaining in the compact is the status of irrigation rights on the Little Bitterroot River. We're still negotiating over those, and we hope to have language on that available soon. That takes us through Article 3. I know I'm moving quickly. I know some of you have seen this before. We'll make this available on our website, and I'm very happy to take questions. But I figure nobody wants me to go on for 3 hours again, which is what I did last time. Article 4 is the implementation article of the compact. It's the administration part. It provides the ground rules for the use of the tribal water rights, and it provides for the unitary administration system that I touched on before. It's got some basic language recognizing some of the fundamental principles about Indian reserved water rights. The rights are to be held in trust by the United States for the tribes. It can be used by the tribes, tribal members, allottees, or anyone with the permission of the tribes. And they are not lost for non-use. That's one of the major differences between federal reserved water rights and water rights that arise under state law. Registration changes. Existing uses of the tribal water rights must be registered. I touched on that before, and I will get to it later. In addition, it provides that new developments and changes regarding use of the tribal water rights must be done pursuant to law of administration, which we're calling the ordinance. And that again goes to the fact that the Water Management Board and the unitary management system that we're proposing would have jurisdiction over all of the water rights on the reservation. Tribal or non-tribal, everyone goes before the Water Management Board equally. And this is part of the language that makes that plain. Leasing is another area that folks have a lot of questions about. We have included leasing provisions in, I believe, every single one of the other Indian compacts that Montana has negotiated. We have them here as well. There are certain categories of water available for leasing. The documents spell out which ones. And one of the key principles is that the leased water cannot adversely affect existing users. And that again is one of the core points, not just of the protection of existing users, but of the way that the prior appropriation system works. People have the right to the stream conditions as they found them. If the lease is for use on the reservation, the adverse effect determination will be made by the Water Management Board. And if it's for off the reservation, it will be made by the DNRC under the Montana Water Use Act, not under the ordinance. Nothing that we're proposing here for the Water Management Board or for the Unitary Administration Ordinance applies off the reservation, because the Montana Supreme Court decisions only dealt with divesting DNRC of jurisdiction on the reservation. We're not changing any of the administrative system off of the reservation. In addition, owners of tribal trust land who have an individual right to a portion of the tribal water right may lease their water for use on the reservation. Again, that cannot cause adverse effect to existing users, and because this would be a non-reservation use, that adverse effect determination would be made by the Water Management Board. Flathead System compact water, which is the 229,000 acre-feet right I talked about before, with the 90,000 acre-feet of Hungry Horse water included, can be used on or off the reservation. If it's for stored water only, the tribe simply need to provide notice for accounting purposes, because once water is stored, it's out of the priority system anyway. That's a matter of state law. Any portion of direct flow, so water not stored in Hungry Horse, but directly from the main stem of Flathead River, again, is subject to an adverse effects analysis. For leases off the reservation, that adverse effects analysis will be done by the DNRC under the Water Use Act. The state is also continuing to negotiate, and this is the other remaining gap in the draft documents, to make 11,000 acre-feet of that Hungry Horse water available for off-reservation mitigation in western Montana. And we're hoping to have language about that available very soon. So now we get to the Water Management Board and the provisions of the compact that actually deal with creating this board and establishing the board's jurisdiction. It's the entity to administer all of the water rights on the reservation, and it's proposed to have 5 voting members, 2 appointed by the governor, 2 appointed by the tribes, and a 5th selected by the other 4. The United States has raised the possibility of a 6th non-voting member. That is something that the parties are still considering. There are some specific criteria over who is eligible to serve on the board. First off, it's got to be a reservation resident, and that's defined to include those 3 conditions. Someone who either does business on the reservation, or lives on the reservation, or is a seasonal resident on the reservation. And then they've got to have education or experience in relevant fields, and that's the list of those up there. There are provisions in the compact about how the board can act. It requires at least 4 voting members for any board vote. That essentially makes sure that no decision can be made exclusively by the appointees of either side. In addition, a vote must pass with a majority of the voting board members. So no less than 3. If you've got 4, it's a 2-2 split. Whatever's under consideration fails. The board responsibilities include what is necessary to administer water rights on the reservation, to issue new appropriation rights, and to do changes. And the powers and duties of the board are essentially to do all those things and to carry out specifically what we detail in the ordinance. And I'll get to the ordinance shortly. But again, the ordinance is essentially the Water Use Act for the reservation. And one of the reasons that the draft is 130 pages long is that we want it to be very clear and very specific about what the rules of the road for the board are, because this is a new regulatory entity that we're talking about creating, and we don't want anyone, especially the board itself, to be unclear on what it is entitled and empowered to do and how it's supposed to go about doing its job. Recognizing that this is a new regulatory entity, we also need to make sure that people's due process rights are protected. And large portions of that, we believe, are accomplished through the policies and procedures, I should say, Freudian slip dick, I apologize, but through the procedures set forth in the ordinance. But that said, we also recognize that it's important to have the possibility of judicial review if someone is not satisfied with the way the board determines an issue. The board is also a public agency subject to right to know laws, and the board cannot change the ordinance by itself. The ordinance can only be changed by the state legislature and the tribal council acting in concert to enact parallel changes into the laws of both. The board can't change it by itself, and neither the tribes nor the state can change it acting alone. Article 5, we're now down to Articles 5, 6, 7, and 8 of the compact, which lawyers care about but are less important in terms of the substance of what we're doing than Articles 3 and 4. Disclaimers and reservations of right. We're not affecting other compacts. We are not establishing precedent for the litigation of other reserved water rights. We're not altering anyone's legal rights in a way that is not specifically set forth in the compact. The United States can only be bound by Congress acts. Various of these things that are just the basic legal framework of what we are and are not doing. Article 6 is contribution to settlement. One of the things that Indian water right negotiations allow is the resolution of water-related damages claims that tribes have against the United States for the United States' failure to protect the tribe's water resources. And so one of the things that generally comes with Indian water settlements are significant amounts of federal money to deal with those essentially breach of trust issues. And those are generally handled in negotiations between the tribes and the United States in the context of the federal legislation. that is necessary to ratify the compact. The state generally also makes financial contributions to settlement. We have historically, in our other settlements that we would expect to do here, pegged that level of contribution and the uses to which that contribution is put based on the benefits that we have bargained for the protection of existing water users. Article 7 lays out the process for how we get this thing all the way done. Legislative approval is only the first step. After the legislature approves this, it will then need to go to Congress for action, then to the tribes for approval, and finally to the water court to incorporate the water rights into decrees. And that's what is dealt with in Article 7. And then Article 8 talks about legislation in defense of the compact. We commit to doing, the state and the tribes commit to doing the things that are necessary to get the settlement finalized. We can't bind the United States until Congress acts, but once Congress acts, the state, the tribes, and the United States are all committed together to defending what we do here, assuming it is in fact finally approved through the political process, from challenges that may be brought to it in court. That's the compact. I'm going to do the ordinance more quickly than I did last week. The draft order 2 weeks ago, I guess it was. The draft ordinance has been available on our website in various generations, from September of 2011 to March of 2012. The version we put up a few weeks ago is very similar to the March 2012 version. We've done some cleanup of terminology and consistency. There are a few new substantive sections that I will highlight here. But the draft ordinance is ultimately, it's the rules of the road for the board to follow and for people who want new water rights or to change existing rights or to enforce their water rights on the reservation. And it's for all on-reservation water users. Again, and I've said this a couple of times, but it's important, the ordinance applies equally to all reservation residents. Everyone goes before the board equally and on the same footing. Again, the ordinance can't be amended by anyone acting alone. It requires joint tribal and state action to change, and it does not apply off the reservation. Just touched on that, a couple of things that are in the ordinance. We talked about these in multiple meetings. The ordinance includes a streamlined process for the issuance of small, new domestic and stopwater uses. It also contains the registration provisions. And this is now where I'm actually going to talk about that. I've teased it a couple of times. There are two parts of the registration process, one of which, and this is a new language that was not in the March draft, deals with the registration of existing uses of the tribal water rights. And then the second one, which was in the March draft, although it cleaned up the language a little bit but not changed the substance, deals with certain categories of state law-based uses that also would need to be registered. The registration of uses of the tribal water right creates a process for those folks who have discrete individual uses now of a portion of the tribal water right to get those uses registered so that they can be administered and protected. The registration of the previously unrecorded uses is important, again, to bring in certain categories of use that presently do not have clear legal validity under the law as it stands. There's two different categories, really, of people who need to register those unrecorded uses. The first category are those folks with direct from domestic or stock uses who did not have to file a claim in the adjudication. Under the adjudication, the general rule is that you did not file a claim to a water use with a priority date prior to July 1, 1973. That right is, as a matter of law in the state of Montana, conclusively presumed to be abandoned. So if you didn't file a right in adjudication that you think you have a pre-73 date for, under Montana law, that right doesn't exist, unless you have one of these direct from the source domestic or stock uses. That was the one category, the two categories of water rights that did not have to file an adjudication. So those are legal rights recognized under Montana law, but unless you voluntarily filed an adjudication, there's no documentation of that use. And so that we can appropriately protect and administer those uses, we want them registered through this process so that they're on the books so that they can be protected. The other category are those people with post-73 domestic or stock uses who did not file completion forms with the NRC for a domestic well or for a small stock development that would have been accepted from the permitting requirements of state law. There are certain exemptions from the permit requirements in state law for small domestic and stock uses. But as a result of those Supreme Court decisions that I mentioned earlier, Since August 22nd, 1996, the DNRC has not been able to process those certificates of completion. If you go and file one with the DNRC in Kalispell or Missoula, they'll take it, they'll take your money, they'll put it in a drawer, and it will be noted as it's suspended because of those court cases. We need to make sure that those uses of water that have gone into the ground, that people are relying on, have legal validity. And so that's the other category of registration. Again, I touched on this briefly. There's been a fair amount of technical changes to the March draft. If you were to lay them side by side and do a red line, you'd see a fair amount of red. But by and large, the substance of much of the document has not changed. There are a couple places that have changed, though. Either they've been added to ensure consistency with the compact, or they were issues that we didn't have provisional agreement on when we released the March draft. Very clear about what the public meetings and records requirements are, clear about the quorum of the board and the powers and duties of the board. Those both track the compact language, which we didn't have available in March. In addition, there's some language about resolving disputes from the FIP water use agreement, and the reason that's there again is that in the draft FIP water use agreement that's out to the public, as part of the dispute resolution process there, it calls for a role for the Water Management Board. And so we need to make sure that assuming that the agreement is done that way, the board in fact has jurisdiction to do what the draft water use agreement contemplates. Again, the sections about registration of existing uses of the tribal right are new. And then the development of the enforceable flow schedule is new. I touched on that briefly before in that section that is labeled other in-stream flow rights. And I gotta tell you, if you look at the documents, if you've got a better suggestion for a name than that one, we're wide open to it. But in any event, for these other in-stream flow rights, the ordinance specifies what the process is for the tribes developing enforceable levels for them. And the reason that's important is that they're not enforceable until these levels are developed. And these levels must be developed in a way that reflects a water budget that protects existing users. So that again is one of the balances that we're trying to strike between the recognition of the tribe's legal water rights with the protection of existing users. That is a core state goal. Again, as I touched on that, so moving ahead of my slides, there's a public process for the development of these enforceable flow levels. First, the tribes need to conduct an informal public process as they put together the level for board consideration, and then the board itself, when it is considering whether to adopt these flow levels, also has to have a review process. And that's very similar to the process that exists for new appropriation rights and changes. In addition, sections 2-2-125 and to 2-2-127 of the ordinance are new. That again is the process for, I talked about before, the state-based water rights that the tribes acquired when they bought land. That's the process for what happens if that land is taken into trust. And then in the enforcement provisions, which are chapter 3 of the ordinance, there's been minimal changes to the bulk of them. There are some new sections that have to do with the appointment of water commissioners. There's been a fair amount of discussion among the tribes in the state of the United States about whether there was a need for water commissioners. And ultimately what we decided is that while nobody could point to the fact there'd be a clear need now, we wanted to make sure that there was the possibility of appointing in the future if there was a very clear need. And as part of it being really a very clear need, it has to be the trigger. Water commissioners may only be appointed by unanimous vote of all 5 board members. That's a different standard than for the rest of the board decisions because we don't want there to have to be water commissioners and the expenses associated with water commissioners unless there's a real clear need for one. And those new sections of the ordinance deal with what the water commissioner's authority will be if, when, and if one is appointed. So that's a quick walkthrough, relatively speaking. And if you want additional information, these documents are up on our website. We really very much want public comment. If there are questions or comments now, we'll be delighted to hear. Thank you very much. Well, I couldn't have done that good a job, so possibly put you all to sleep.
Was you open for questions?
Absolutely, Lloyd.
I have several questions I'd like to ask.
Jay, can you hear me back there? As you probably know, I'm a former water attorney, and I'm 87 years old. My memory isn't too good, and I'll have to apologize for errors in memory and that, but I would like to make some comments. Number one, this compact provides for federal jurisdiction, federal court's jurisdiction over all questions involved in this, does it not?
No, where the exclusive federal court jurisdiction exists is for disputes that arise under the Fifth Water Use Agreement, if that agreement is ultimately entered into. The Fifth Water Use Agreement itself, as the draft went out, that the joint board and the tribes and the state negotiated, has a long dispute resolution process involving a stop at the Water Management Board, but the only court jurisdiction under the Fifth Water Use Agreement is federal court. Under the compact, however, we have this court of competent jurisdiction language, which means depending on the particular facts and circumstances of the dispute, federal court may have jurisdiction, state court may have jurisdiction, tribal court may have jurisdiction, and we are not presuming that only one of those forums is necessarily available under the compact and under the ordinance.
As a matter of fact, though, the federal courts are lined up to have jurisdiction over most of the important questions, aren't they? Our state court and our state constitution gives us jurisdiction over water within the boundaries of the state. And the McCann Act backs us up, and the Northern Cheyenne case in the U.S. Supreme Court backs us up, doesn't it? Yeah, it does.
I'm not sure which Northern Cheyenne case you're referring to. What McCarran provides is that state courts have concurrent jurisdiction with federal courts over federal and Indian water rights if we are adjudicating them in a general stream adjudication, which we are. The reason that, unlike the Fifth Water Use Agreement, where there is the provision for a specific court review, which is federal, we're not going to agree that state courts can't review some of these things in the same way that the tribes are not going to agree that tribal court couldn't possibly review some of these things depending on the nature of the factual dispute. So what we are providing for in these documents is a court of competent jurisdiction, and it's for the courts initially to determine their jurisdiction.
Well, thank you. Your explanation is as confusing as all the documents and crap that you've got in this compact, sir. Now, the other thing that I'm concerned about, you make a lot of ado over fish rights. Confederated Salish and Kootenai tribes never knew what fish were. Hell, they were down in the Buffalo Straits hunting buffalo. But we were relying heavily on the fish rights of the Confederated tribes. That's ridiculous. Now, another thing that I'd like to ask you about. We talked about this the last time. You have a conflict of interest, do you not?
The short answer is no, and I'm going to hand it over to Chris at this point.
Explain this thing.
The answer to your question is no.
What?
I said the answer to your question is no.
No conflict of interest?
That's correct.
You don't represent a tribe or a firm, and not a member of a firm down in Phoenix, Arizona, that exclusively handles Indian rights. Is that correct?
I have an association with one in my private capacity, yes.
You're a member of that partnership down there, aren't you?
No, I'm of counsel lawyer, which is a relationship as a lawyer you should understand.
Yeah, and you're of counsel.
Correct.
And being exclusively for tribes, Indian tribes, you don't think that's a conflict of interest?
No.
No? Well, what about your membership as an assistant attorney general?
What about it?
Aren't you an assistant attorney general?
Yes.
And you're still a member of another firm down in Phoenix, Arizona, aren't you?
In my private capacity, I am, as opposed to my state capacity.
I see. What's the private capacity as opposed to your public employee capacity?
Lloyd, public employees have the right to hold employment outside of the scope of their public employment.
I see.
The case is Wadsworth against the state of Montana. That provides that under the Montana Constitution, a public employee cannot be prohibited by the agency that employs him or her from holding outside employment in order to
Well, you admitted last time you had a conflict of interest, but you made up for the
No, we
conflict.
didn't.
Yes, you did. You said, well, we have no conflict of interest because we have notified the parties. Isn't
What
that
we said-
correct?
No, it's not correct. What we said last time is there's no conflict, but to the extent there ever might be a conflict, it's been disclosed. The Compact Commission, through the hiring process, has waived it. And by the way, there is no instance in which there could possibly be a conflict between any of the water rights that are at issue in this compact and any property rights of any kind belonging to the tribes of the Southwest with which the firm that Jake's associated with does business.
Okay, but you
Water
are
flows-
waiting,
water flows
the
downhill.
tribes in the Southwest are waiting for you to come up with a decision in this thing and see whether you get this passed. Isn't that correct?
No, the tribe in the Southwest I was doing the water work for actually fired us last January.
No, they haven't.
Yeah, they haven't. If they haven't, can you give me the checks then that I haven't been getting?
Well, okay. Okay. Now, what I'm concerned with is this, excuse my mental deal here. You feel that the federal court should have jurisdiction in this, I take it that way.
No, I haven't said that at all.
And I can tell you for a fact that we've never been advised by Jay that the federal courts ought to have jurisdiction in this matter.
What's your relationship to this board?
I'm the chairman of the Compact Commission.
You're what?
The chairman of the Compact Commission.
Oh, I see. Now, you're aware,
Duly appointed by the Attorney General.
you're aware that there are 6 other compacts here in the state, isn't there?
There are actually 15 or 16 other compacts in this state, 9 or 10 of which with federal
How many
agencies.
tribes do we have?
We have 7 reservations. So
And we have compacts with 6 other reservations,
That is
haven't we?
correct.
And how many of those have been approved by Congress?
Northern Cheyenne, Rocky Boys, and Crow. Fort Peck was structured in such a
The others are about 4 years old and waiting for,
Fort Peck, which was the first one, was structured in such a way that it did not require congressional approval, and it has in fact been approved by the water court and is enforceable.
and they haven't been enforced or haven't been passed by the Congress, have they?
Fort Peck was not structured in the way that it required congressional approval. It was approved by the executive branch agencies that had jurisdiction over it.
This compact with the Flathead tribe is absolutely different from the compact with the other tribes, is it not?
No, it's not absolutely different. It has some significant differences and some significant commonalities.
Significant that you're taking jurisdiction all over the western Montana.
Well, I'm not sure how many times I said it in the presentation, but I'll say it again now.
Well, I want you to
Nothing that
know
we
that-
are doing in this compact changes the jurisdictional framework off the reservation. Your statement that this changes the jurisdiction of western Montana is wrong.
It is wrong. It's a jurisdiction in western Montana, you're taking jurisdiction over the Flathead, the Swan, all of the Bitterroot, and the whole works in
We are not changing the jurisdictional system that applies. The NRC and the district courts are the regulatory authorities that have jurisdiction over water off the reservation. We are recognizing water rights that the tribes are legally entitled to in some of those basins that you
fishing
named.
rights.
And that flow from the language in the Hellgate Treaty, yes. But those water rights will be administered in the same fashion as all other water rights off the reservation are administered, that is by the NRC and the state district courts.
Okay, well, I want you to know it doesn't matter a damn to me. I'm not gonna be around to be affected by it. But I'd like to represent some of these people that are gonna be seriously affected by it with the values of their lands and everything else that's coming up in the compact. Thank you.
I have a comment. John Swenson of Ronan. I have a question about the registration of existing use non-registered. What is the process? Any explanation of what the process would be roughly?
Sure. The specific process is set forth in the sections of the ordinance and goes into some pretty heavy detail about what is necessary. Essentially, what it requires is submitting similar information for the state registration of use. State registration of uses would require essentially submitting the same information that you would need to submit to the NRC to get an exempt right off the reservation. It's either when you drill the well, what the flow rate of your well is, where you're using it, where you're diverting from.
I'm ignorant of that registration process he's referring to. Does it require a signature of the applicant or the registrant?
What we are, for certain, if we're on the reservation, the applicant will need to sign the forms. Yes, and I believe that's true for the DNRC forms as well. I see Candace West, who's the chief legal counsel for DNRC, nodding her head to that one.
What tool will you use to compel a man or woman to put his signature or his seal on a document?
No, you're free not to register. However, if you do not register a water right that is one of the post-73 rights, then your claim to that water right will be deemed abandoned, similar to how water rights, pre-73 rights are dealt with under state law. So it's a voluntary choice. If you choose not to register, that is entirely your prerogative. That simply means that you will not have legal protection for your use of water.
Jay, there's no seal, it just has to be signed.
Yeah, there's no where to seal.
Yeah, well, your signature is your seal. Question. Definition of individual is, or individual, the term individual is used in your document, your most recent document, but it's not defined. And I just want to put on the record that it's not defined and that I would like to see it defined. Black's Law defines it as a single person. Now, you do use the term individual to describe the definition of the word person in your document.
The definition of person includes individuals. The definition of person is broader. It can include corporations. It includes governmental entities. The intent behind individual is, as you suggest, to talk about a single person, but we can certainly look at putting the definition in the document.
Thank you very much.
I just want to go on the record here that we do know what fish are and have always known what fish are.
Yeah,
So let's clear that up.
yeah,
Duly noted.
yeah, very much.
The gentleman back there has to say that.
One of the experts who had written about the history of the Salish including 1937, Tony High, who was an anthropologist at the university, points out very clearly three bands of the Kootenai. The Kootenai in Canada, the Tobacco Plains band of the Kootenai, and the Dayton band of the Kootenai, who were known as different from the others because of the weirs that they installed in Dayton Creek for the fishing, which was one of their major subsistence foods. That was published originally in 1937.
Question regarding the advantage of having a closed basin in the western Montana. So you mentioned something about 90,000 acre feet being provided as part of the settlement to the tribes, and so I have a couple of questions on that. What does 90,000 acre feet equate to in gallons?
It's roughly 340,000 gallons per acre foot, so I'm not a mathematician, but I'm guessing 27 million gallons, roughly. That's ballpark.
I think it's probably closer to about 30 trillion gallons, wouldn't you say?
You know, I just sat here and did that math in my head, so I'm happy to take your word for it as well. At the end of the day, it's 90,000 acre feet. An acre foot is the conventional measure of water. It's enough water to cover an acre 1 foot deep, about the size of a football field.